Well, good afternoon, everybody. It's now 2 o'clock, so it's time to resume the hearing sessions into the examination of the submitted Crawley Borough Local Plan to 2040. Hopefully everybody can hear me and where necessary see me. For those of you who haven't attended previous sessions of these examination hearings, just to introduce myself, my name's David Spencer. I'm one of two inspectors appointed by the Secretary of State to carry out the examination of the submitted plan, alongside, on my right, my colleague Mr. Glenn Rowlings. Please can I ask that people ensure that mobile phones are switched off or on their silent settings, please. And because I think there are people here for this session who weren't here at this morning's session, I'm going to turn to my left to Charlotte Glancy, the Programme Officer, who I think will take us through the necessary and important housekeeping points, please.
Afternoon, everyone. So this is just an update about recording and the fire safety. So there are no scheduled fire drills, so in the event of a fire alarm sounding, please leave the building via the main spiral staircase and through the main entrance doors. Once outside, please turn left and make your way to the fire assembly point located beyond the Town Hall multi-storey car park on Exchange Road. If you're unable to use the stairs, please wait in the chamber and you'll be guided by a member of staff to the evacuation lift. These hearings are being filmed and recorded to be later uploaded on the Council's YouTube site. So to be aware that the Council is a data controller under the Data Protection Act. Data collected during a webcast will be retained in accordance with the Council's published policy, and these specific hearings will be retained for at least 2 years. Any individual seated around the chamber and in the public gallery will be filmed by the automated camera system, and your image may be captured. Therefore, by entering the room, you're consenting to being filmed and to the possible use of those images and sound recordings for webcasting and/or training purposes. I think everybody knows about the mics, so I'll leave it there. Thank you.
Thank you, Charlotte. Hopefully everybody's here this afternoon for the discussion on Matter 5, which relates to the plans, proposals and policy framework relating to Gatwick Airport, obviously a significant area within the plan area. Before we set out the agenda for this afternoon's session, just a reminder that these are obviously hearing sessions. There are an opportunity for everybody to come forward and add to whatever they've already provided to us within writing via various statements that have been received in response to our matters, issues and questions published at the beginning of October. Together with your original representations. I think there's been 3 opportunities to submit representations on the plan, and they are all before us. We will try and bring people into the discussion as we go along, but as this morning, the convention is, if you do wish to raise a particular point, just upend your nameplate and then I'll try and bring you in. People on the back row to my left, if you are going to be participating, you're going to have to probably try a bit harder, I'm afraid, to grab my attention, just because of line of sight issues, but I'm sure you'll let me know if you wish to contribute to the discussion. It is only people around the tables who are able to participate, so anybody observing this session from the public gallery, you are not, it's not open to wider discussion, only those around the table who've expressed their right to be heard. In terms of the agenda for this afternoon, there is sort of one procedural issue I just want to cover first before we get into the agenda itself, and I invite people to identify themselves. I think it has become aware, I think, or more widely understood, that's appended to the Borough Council's statement for this hearing session at Appendix A is a brief paper prepared by York Aviation that draws principally on existing material, I think provided by Arup on behalf of the airport and by Mott MacDonald on behalf of Gatwick Green Limited. It's not been identified specifically as one of the additional new pieces of evidence that we're currently seeking further comment on, but we do appreciate and acknowledge that it has come into this sort of the examination arena at a relatively late stage, and I think in mind, Gatwick Airport have requested further time to consider and potentially respond to the contents of that paper. That is something we have agreed to, and I appreciate that then leads to potentially some confusion about what we can talk or not discuss this afternoon. I think in terms of if people have got the agenda to hand, we've got it's 4B, Roman numeral 5. I think in identifying the council's additional paper, it was our way of... Hello, somebody at the back? Okay. Okay. Thank you. I think we were anticipating the people who've turned up would be here this afternoon, so thank you for joining the table, bringing that to our attention. So just to get back to where we were on the agenda item point 4B, Roman numeral 5, I think the intention here was to try and bring some additional attention to the fact that this paper had been provided. I think rather than getting or focusing too specifically on that paper, given that it largely draws on existing material, I am going to permit and allow discussion on it today in terms of, when we come on to this matter, the impact of the council's approach on the kind of the wider operational activity or ambitions or objectives of the airport. But that is against the backdrop that we have obviously allowed that the airport additional time to respond to this paper. If in light of those responses, and we'll give the council and potentially others the opportunity to look at those, or we will certainly give the council the opportunity to look at those, we may ultimately need to reopen the hearing discussions in due course. But having looked at the York Aviation paper, it is only 5 pages. As I say, it largely draws, as I see it, as material that already was in the examination arena. I think we can still have some high-level, in-principle discussion today, but I reserve the right that if we do receive further submissions from Gatwick Airport in writing and reflect on those, we may need to reopen the hearing discussions in due course. I mean, that is within the general principle for all local plan examinations. Whatever we receive in writing carries equal weight to whatever is said in this room and in these hearings. I see that's listed a need to respond from Ms Sargent for the airport.
Extremely briefly, sir, only to say that part of the reason we had to request an extension of time is because the member of our team who would be dealing with that is unavailable for personal reasons. So I hope you'll understand that we will probably not be dealing with the content of that paper in any detail this afternoon, because we do wish to take the opportunity to respond properly in writing.
Okay.
Yeah, it is Mr. Pereira, sir, and can I just introduce myself because I haven't spoken yet. I hear entirely what Ms Sargent's saying. Of course, we've produced the evidence from Mott MacDonald, and we didn't understand, and perhaps Miss Sargent can confirm, that GAL are changing their case. And their case so far has been not to put in any technical challenge to Mott MacDonald. And it's also been to rely entirely on the Arup material for the parking justification. And obviously if GAL were going to change their case, we would want to know, but that's not been something they've alerted any of the parties to. So they ought to be in a position to deal with the technical parking matters that are raised by Mott MacDonald, and Mr. Mayor's here to do that. It's been on the agenda, and certainly from our perspective, we are expecting that to be dealt with, and we're not expecting, whatever they might put in by the December deadline, any material change to their case, because we would have expected them to have responded to Mott MacDonald by now, because it's been in since June.
Okay. Thank you. I don't know, Ms. Sargent, whether you were able to confirm that. Confirm any of that at this stage. I mean, obviously mindful that the Arup work is appended to the GAL statement of case statement for these hearing sessions.
Yes, so we continue to rely on that work. In terms of responding to Mott MacDonald, I mean, the respect in which we are disadvantaged today is that the member of our team who would have been tasked with doing that is unavailable for reasons that I'm afraid are completely out of everybody's control. So I don't think I can assist further than that, but we're not departing from what we've put forward in the Arup work.
Thank you. Does that assist, Mr. Pereira?
I'm grateful for that clarification. Thank you.
Okay, thank you. Well, as I say, we'll proceed on that basis. We'll see what ground, again, we can cover. We've got a reasonably full agenda for this afternoon, and I think it's become clear from previous, well, I say we're only sitting on day 2, but it's become clear from various discussions the significance of the approach to Gatwick, and in particular safeguarding to this plan and this plan examination. As Charlotte mentioned, these sessions are being recorded. I think it's helpful for anybody who's going to subsequently watch these recordings, or and certainly to myself, to understand who is here today in terms of speaking to the examination on this issue. If I can start in the usual way, please, with the Borough Council and the team that's going to assist the examination this afternoon.
Hello, yes, thank you. I'm Sally LePage, the Strategic Planning Manager for Crawley Borough Council. On my left is David Forsdick, KC, supporting us, and at the front table as well, Anthony Masson. Thank you.
And if I, continue to the right of me on the front row of the table, who else am I likely to be hearing from this afternoon?
My name is Nigel Wharton. I work for a consultancy called Jacobs. We're spatial planning consultants to National Highways.
I'm Nigel DeWitt, National Highways.
And then if I can move round to my left from the front, and we start with Mr. Pereira again, please.
So thank you very much. James Pereira, King's Counsel, representing Gatwick Green. I'll be probably bowing out after certain matters have been dealt with, and then there's Mr. Mayor from Mott MacDonald. You just put your hand up. There, who'll be coming into the seat afterwards. Thank you.
Thank you. And moving along, please.
Thank you, sir. My name is Tony Cross, and I'm representing Gatwick Green. I'm a strategic transport planner.
Bandit Malhotra, Head of Planning at the Aurora Group.
Michael Rees, Director from LRM Planning.
Adam Perg, I'm a Director at RPS in the Town Planning team.
Heather Sargent, Landmark Chambers, Counsel for Gatwick Airport Limited.
Thank you. And then along the back row at the left, please.
Suzanne Holloway from Vale Williams, representing Ardmore Limited.
Graham Keane, King's Counsel, representing Ardmore Limited. So.
Hayden Kreutzer from Quad, representing the Barker Trust.
Lydia Granger, Planning Manager at Gatwick Airport Limited.
Tim North and Associates Limited, representing Holiday Extras Limited.
Nick Mayer, Head of Airport Planning from Mott MacDonald.
Simon Fife,
again, Savills, representing Gatwick Green Limited.
I'm Laura Brooke. I'm from Sussex Wildlife Trust and I'm a conservation officer.
Could I just... Sorry, could I just ask that we can introduce our colleagues from West Sussex that are supporting us this afternoon?
Yes, please. Thank you.
Hello, Guy Parfett from West Sussex County Council, Transport Planning and Policy Team.
Eric Singy from West Sussex County Council, Transport Planning and Policy Team.
Thank you, everybody, for that. So if we turn to the agenda, please, for item 5 on Gatwick Airport, just in terms of just introduction and just brief setting out what we consider to be some of the key soundness issues for this plan examination. Obviously, we're mindful that sustainable growth at Gatwick Airport is part of the plan's visions in terms of supporting the economy, and the airport is identified as a major as an economic centre, paragraph 218 of the plan, reflecting that the airport is a major source of employment within the borough and obviously surrounding areas both directly and indirectly. We read with interest it's described as the busiest single runway in the world, and consequently whilst there are benefits to the economy, other matters relating to the operation of the airport need to be considered, including noise and how airport users access the airport in terms of the impact on the environment of the borough. In terms of overarching soundness issues for the plan, we'll need to look at whether the plan provides an effective policy framework for managing individual day-to-day applications and proposals at the airport, obviously noting that there are certain permitted development rights. Secondly, whether the plan is justified in addressing Gatwick on a single runway basis, and how things potentially fit at the moment with the concurrent development consent order application for the Northern Runway project, and whether the plan is sound in continuing to safeguard future runway development at Gatwick, and whether that remains an appropriate strategy for this plan, which is potentially for at least the next 5 years until around 2030, when consideration is likely to be given to a further review of the local plan. Obviously, there are various things we'll have to bear in mind in terms of the soundness of the plan and in relation to Gatwick, in terms of the progression of national aviation policy since the 2015 local plan. We obviously now have in front of us the Airport Master Plan of 2019 and the latest Airport Surface and Access Strategy of 2022. We also have the Council's topic paper number 2, which deals with Gatwick, and obviously various contextual documents provided by Gatwick Airport Limited as part of their statement for these hearing sessions. I've mentioned the development consent order process for the Northern Runway project. I think we're mindful that the local plan examination is progressing in advance of that process, and we're keen to maintain an appropriate distinction from what is being examined as part of the Northern Runway project. Obviously, our task is to focus on plan soundness and whether the plan itself provided a sound basis at the point of submission at the end of July. I think we'd also like to just very briefly draw participants' attention to the fact that some aspects of policy for Gatwick will be dealt with at the Part 2 hearings in January, including policy GAT3 on airport related parking. So that's very briefly our sort of scene setter for this session. So if I turn to agenda item 2, and it's the soundness of local plan policy for the existing airport, obviously having regard to the airport master plan, and principally in terms of the plan starting at policy GAT1, GAT1, in terms of the framework for dealing with development proposals at the airport itself, and having reference to our MIQs 5.1 and 5.2, and possibly some others, but I'll just perhaps give the Council the first sort of opportunity to just set out how it's approached the planning policy framework for the kind of the existing sort of airport configuration, and in terms of how it's responded to the airport master plan, and how the airport boundary is shown on the policies map.
Yes, certainly. So I would refer you, sir, to our topic paper, Gatwick Airport, particularly section 3.1, that's DSTP02. We have covered the issues about the airport boundary there, and we haven't simply rolled forward the airport boundary from the 2015 local plan. We've taken account of the master plan boundary changes where appropriate to a local plan policy boundary, and I draw that distinction. I think we feel there's a different purpose to the airport master plan and the section 106 boundaries, which reflect Gatwick's ownership as opposed to a planning policy boundary. And in our view, there's a significant difference in the policy approach on either side of that boundary, particularly, for example, in relation to airport parking applications on and off airport, which obviously we'll touch on further in January, but also airport-related employment and also our hotel policy. So, for example, in reviewing the master plan boundary and deciding what's appropriate for the local plan, is we haven't included countryside areas to the northwest and southeast of the airport. We've also excluded Brook House as the immigration removal centre, as it's not an essential use to the safe and efficient operation of the airport. But then in other regards, we have agreed and accepted the changes that were made in the master plan. For example, in excluding Schlumberger House, which is the Aurora's interest, as that building, the office building there, has not been for a long time in an airport-related use. Office use obviously remains appropriate in that building. It doesn't need to just be in a main employment area. And the safeguarding that it's now subject to doesn't prevent enhancement of the building. And actually, we heard this morning there's a potential slight change of approach, potentially from Gatwick, on how far buildings within the area can be changed into safeguarded areas. So that might be another one that we would discuss. And I think we said we'd discuss that in more detail.
Thank you for that. I mean, in terms of dealing with our sort of matter and issue question 5.1 in terms of the airport boundaries, you say, Mr. Lepage, is a airport boundary for sort of planning policy purposes, whether that's soundly based. I don't know, there's bring in others who may have alternative suggestions or approaches to that. Obviously, Aurora's interest has already been identified, so I can bring in Ms. Malhotra, please.
Thank you. I understand and agree with the Council insofar as the airport boundary should not be based on ownership. However, it does seem like the bulk of it has been based upon ownership. From our perspective, we are selfishly just asking about one or two particular sites within the perimeter of the airport boundary. But I do question whether the inspectors are satisfied that there is sufficient evidence within the local plan for the forecast demand of office space and other ancillary space. It appears, and I might be classed as unjust in saying this, that Crawley Council has taken the master plan on face value and has not really questioned whether there is adequate demand for offices and so on within the defined boundary of the 2019 master plan. Now, Crawley Council have themselves questioned the master plan, and specifically with respect to office accommodation in their own topic paper 2, where they identify that there are contradictions in the GAL master plan of 2019 in that there is in some parts a surplus of office space, and in others a need to provide more offices. I appreciate this might be geographical, but they are contradictions. From our perspective, we have an office building which has circa 12,000 square metres of viable, sustainable floor space, which is accessible from within the airport perimeter road. It doesn't have any other access to the road network that could provide the office accommodation, also provide the Grade A office accommodation, which is identified as a need within the borough, within a sustainable location of the airport boundary. Ownership isn't a material consideration, as Crawley have outlined, and we feel that the plan is currently unsound insofar as it's not considering brownfield development in sustainable locations.
Thank you. So can I deduce from that, Ms Malhotra, that what you would say to us in terms of remedying a soundness issue would be to amend the airport boundary to include your property at, is it Schumberger House?
There are lots of pronunciations of this building. So we have in Aurora call it Schlumberger, but that's by the by, yes. At the moment, the property is within the airport boundary in the adopted local plan, and our request is that it's retained within the airport boundary going forward. It's moved as a proposal by Crawley Council into the safeguarded area.
Okay. And in terms of what the council has reiterated this afternoon, that in terms of an office use there is still a valid approach. It seems that the council's approach is whether there's been a kind of a functional link between the use of the building and the airport, and it's saying it's on that basis that it's amended the boundary, so it doesn't preclude, as I understand from the council's position, the continued office use of that building or improvements to that office building.
I accept that the safeguarding allows for refurbishment. However, it's a fairly inefficient building at present, and it doesn't currently meet the commercial requirements for letting it out again without significant value enhancements, which wouldn't then be recouped. So from our perspective, it needs probably more than the small scale GAT 2 definition of alterations in order to make it commercially viable. And for such a sustainable location, it seems difficult to understand why you would take a sustainable location out of the airport boundary.
Thank you. I know Gatwick Airport also want to come in on this point. I've got cards up from Ms Sargent and Ms Granger, so I don't know if there's a sequence.
I saw Ms Granger's card go up, so I'll defer to what she has to say, and maybe I've got nothing to add after that.
Thank you, sirs. I think it's 2 points that we'd like to make about the airport boundary. So that's as is shown in the Gatwick Airport 2019 master plan. The way in which that has been devised, it shows the operational land of the airport, and that's in accordance with the DFT guidance at the time it was published. And then I think the second point that I'd like to make is about, in our view, the boundary that's shown in the policies map is neither one thing nor another, so it's not our operational boundary. But that causes confusion because in terms of the way that we utilise the operational boundary in planning terms, that affords us permitted development rights over operational land. And so there's separate tests that are set out within the General Permitted Development Order 2015 for that. But if it's not clear to subsequent council officers and members of the public what our operational boundary is, then there is confusion caused around what our permitted development rights are. I think those are the main 2 points I'd like to make.
Thank you. So should I be interpreting the airport submission that you'd want the operational boundary to also be shown? Or is there confusion? Both are shown, but there'll be confusion between the two?
Well, I think our view is that the airport boundary, as shown in the master plan, is what should be shown. So Plan 4 in the Gatwick Airport Master Plan 2019 is what we see as the airport boundary.
you mind if I seek clarification on that? Can I just understand, is it being said that the airport boundary is the same as the operational boundary?
That's the case, yes.
Oh, well, that's clearly wrong in law, so I'm not going to respond to that.
Sorry, so is the council accepting that there should be a...
They're two separate things.
Yeah.
They're entirely legally separate. The land ownership boundary and the operational boundary are not the same thing.
And in terms of Gatwick Airport's submission that the airport boundary for the purposes of applying planning policy should be coterminous with the operational boundary.
I think Ms Granger's turned us to Plan 4 in the Gatwick Airport Master Plan, and is suggesting that the whole of the area within that boundary is Gatwick Airport operational land. But I would argue that it isn't, because some of it is biodiversity areas that they have no operational purpose. So those areas don't have the same permitted development rights as operational land. So there's actually a distinction between Gatwick's ownership boundary, Gatwick's operational land, and then our position, which is that we are coming forward with what we believe is an appropriate planning policy boundary. And I don't think the master plan includes an operational land boundary for the airport.
You know, yes, that's something we were kind of trying to find as well, but perhaps we were not going to.
So my understanding is that's correct. It isn't shown. I'll be corrected if that's wrong, but it's not correct for the council to suggest repeatedly that the boundary shown in the master plan reflects Gatwick's ownership. It doesn't, and we've made that very clear in our hearing statement. It includes some parcels of land that we don't own, but that are used for airport-related purposes, which I think goes to Ms Lappage's point. I mean, just to add to what Ms Granger said as to why, I mean, our case is a simple one, which is that it's the Plan 4 boundary that should be included. That's it in a nutshell. And the reasons why, first of all, the master plan recommends that that's the boundary that is adopted by other organisations who want to illustrate the perimeter of the airport. I accept, of course, the master plan isn't part of the adopted development plan, but it is planning policy, albeit formulated by Gatwick, but it was consulted upon. And you'll have seen from the appendix to our hearing statement where we set out what policy has to say about all of these matters, that it does emphasise the desirability of airports producing master plans and the roles that they play. So that's the first point. And secondly, it is the boundary used in the Section 106 agreement, and that's not something that should just be disregarded. It's the living document that is used by the airport, but also by the council and West Sussex County Council to support the growth of the airport and to strike the balance between doing so and minimising adverse impact. So we do say the Section 106 agreement is relevant, and there's an obvious point, which is that I think, as this conversation has made amply clear, the more boundaries there are, the worse it is for everybody.
Is it being said that the boundary on Plan 4 is only operational land?
I don't know what legal definition of operational land my learned friend has in mind here. I'm sure if it's wrong that there's areas of biodiversity and so on and so forth, I'll be told. I'm prepared to accept that it's not. I don't want to get caught up in a technical debate over a legal definition of operational land. Our position is that any land within that boundary that's not in a legal sense operational land is still used for airport related purposes, which might well include things like biodiversity areas and so on and so forth.
Consequence would appear to be a widening of the PD rights that are the availability or the availability of being able to argue that PD rights apply much more widely.
Sorry, if the airport boundary designation is widened or amended.
The PD rights apply to operational land.
Yep.
If you have a plan that is purporting to, I mean, if it's being said that the airport boundary is one and the same thing for everything, it is basically the function of where the airport operations are, then it has to be justified by reference to it being operational land within that boundary. Yeah, I mean, you just can't draw a red line and say we're going to have PD rights wherever we say so. That's just a misconception in law.
So at the time of we keep coming back to the last local plan, but I mean it's not a million miles away, miles away in terms of when it was prepared. So that identified an airport boundary for the application of policy at Gatwick. Yep. The council's reviewed that as part of this process. I think as Mr. LePage said, then there's been some subsequent amendments to that, but also having regard to the master plan. But the council's arrived at a position where the airport boundary is not aligned, or it's not consistent with Plan 4 in the airport master plan. Set out reasons for that. I think where ultimately I'm being led is to, is just do I accept Gatwick's position or the Borough Council's position?
Is the Borough Council's position unsound? That's the question, not which one do you prefer. Is there anything wrong with our judgment?
Thank you. Can I take submission? I mean, is it beneficial that we have a map or a plan that shows the extent of operational land for this exercise?
So I think Gal's view would be that the airport boundary as shown in Plan 4 is the airport boundary, and that is the GAL-controlled land. So I think you have to bear in mind, as we're an operational airport, we will have a operational land boundary. We also have different boundaries to do with landside and airside designations. Now these are sort of operationally sensitive, and we do not publish those. For the purpose of planning policy, I don't think in the formulation of that we would need to publish those sensitive documents. And our view is that the Master Plan 2019 sets out the justification for what the airport boundary should be and how it is formulated. At the point in time that was published, there were some areas of land taken out of the airport boundary, including Schlumberger House, and the justification for that is within the master plan, and the explanation for that, and I think that chimes with what the local authority has said, in that it is not part of the operational requirements of the airport. I think the other thing that I would add is that yes, we do have a range of land uses within the airport boundary, and I think they also go to supporting the ecosystem that is a live operational airport. So we do have biodiversity areas. We have areas of flood mitigation. We obviously have the operational parts, so car parking, hotels, the terminals themselves. So that just goes into sort of the ecosystem of the airport and its requirements. Thank you.
Thank you. I mean, in terms of this issue of the various boundaries and what applies or what doesn't apply, I mean, it seems it's difficult for us to kind of get a plan form or map of where the airport operational kind of land is. But so, how does the council determine where permitted development rights apply or don't to a particular area of land? What basis is the council doing that?
We have we have on occasion had to seek legal advice on whether it's operational or not, and it is on a case-by-case specific basis, where Gatwick have come in perhaps with a suggestion that something can be dealt with under a permitted development consultation, and we've had to push back, and then it's been reissued perhaps as a planning application. So it does vary, and I think we do have a note on it.
Yeah, there's been a battle of legal advices on this historically that Gatwick will know about, where the issue has been comprehensively, if I may speak from my own advices, set out as to what the legal framework is, and it's never been rebutted. So.
Thank you. Are there any further submissions in relation to still our MIQ 5.1 in terms of the airport's boundary? Ms Sargent, and then I'll come to Mr North.
Only to observe that it sounds as though the council doesn't have a map of what it considers to be the operational land either, and it is something that is dealt with on a case-by-case basis in accordance with whomever's legal advice. So I don't myself see how that does provide a robust or sound basis for drafting the boundary in this plan, which needs to obviously not be applied on a case-by-case basis, leaving everyone in doubt until agreement's reached.
Thank you. Mr North, please.
Thank you, sir. From my client's point of view, and I imagine also for many people who are involved in airport-related car parking, it is really essential to know where the operational boundary is, because that determines whether you've got permitted development rights or not. If we don't know what it is, or if there is confusion, then that multiplies for people who are outside, who are involved in airport-related car parking.
Come back to the Borough Council. Yeah.
Yeah, I would just go back to Ms Sargent's point and just reiterate that the boundary that we have drawn in the local plan is not about the operational boundary where PD rights might apply within the airport, but it's a planning policy boundary where the planning policies relating to land within the airport boundary are defined in the local plan.
And that's, for example, the various policies I think we've tried to set out in the MIQ, so for the purposes of some of the things like EC7, which hotel visitor we were referring to earlier.
EC7, GAT3, GAT1, yeah. Oh, and EC4, sorry. No, GAT4.
Okay. Those submissions, I'm going to move on in terms of the agenda, because obviously there's other ground we've got to cover, but thank you for those. And in terms of sort of the second strand of where we started, or what we referred to or touched upon in our introduction, in terms of whether policy GAT1 is sound in terms of, I mean, it's talks about development of the airport in a single runway context. In particular, criterion 2, it seeks to deal with kind of the balancing of the kind of the impacts and benefits where development comes forward, and then finally and ultimately does make a cross-reference to what is now the sort of the concurrent development consent order process. In terms of that sort of general overarching approach in GAT1, is it sound, and can it be found sound in the context of where we are? I appreciate the council probably wanted to submit this plan some time ago before water neutrality held things up, and probably wasn't anticipating being here at the sort of same time as a DCO process, but give the council the opportunity to set out his position on the kind of the effectiveness of this policy approach in terms of managing development proposals at Gatwick.
Yeah, so in terms of just the overarching sort of objective of GAT1, and we have We have amended the policy in the light of some of Gatwick's suggested changes during the various consultations, but we don't support all of them. GAT 1 has been strengthened in light of national aviation policy and the recognition of the need to minimise and mitigate adverse impacts of aviation growth and maximise the sharing of the benefits with local communities. Those are set out in, for example, Beyond the Horizon, making best use of existing runways, which is EGSM GA04, paragraphs 1.26 and 1.29. And, for example, within the NPPF, requirements such as paragraph 8C, making effective use of land, minimising pollution, and 185A, regarding the need to ensure the effects of new development on pollution, on health, living conditions, and the natural environment. I've got specific, more detailed points on certain criteria of the policy, so I don't know if you want to touch on those now.
Can you, if we can look at those now, please.
Going on to 5.7, I think as we've set out in relation to criterion 2 and the fact that, or the suggestion that it doesn't allow for a balancing exercise to be undertaken. As we've set out in our MIQ response, our case is that criterion 5, which recognises the positive benefits and the balance between all 5 criteria, and that's what would be taken into account in that balancing act in decision making. In terms of 5.8 and the reference with compensation and the suggestion that mitigation shouldn't be confused with financial compensation, that's not intended to refer only to financial compensation. We believe the appropriateness of community compensation is established through national policy. For example, Aviation 2050, which is EGSM GA03, paragraphs 3.71 and 3.72, the Airport's National Policy Statement, PS EGSM GA10, in paragraph 5.247, and numerous other references to compensation throughout the document. And also compensation is referred to in paragraph 180A in relation to biodiversity. And a further example of what we're really talking about is also already included in the section 106 with Gatwick, EGSM GA05, for situations where tree replacement is not possible, and then we seek compensation if that can't be done. Turning then to criterion 3 and the suggestion that any CBC wording for compensation, that we should be using sort of national guidance. And I'm also aware that there's been representations there from the Sussex Wildlife Trust and the Woodland Trust. I think we used the word fair. We amended the plan. We suggested a modification in CBLP 07 to replace like for fair on the advice of Natural England, because of the need to go beyond like for like, given the difficulty in compensatory habitat creation. But I do accept that it's less definite, and I think perhaps a more helpful approach has now been suggested, I think, by the Sussex Wildlife Trust and possibly the Woodland Trust, and I hope it also concurs with Gal's representation that we should be using the wording as set out in national guidance. The NPPG uses the wording, as a last resort, compensation is secured to ensure equivalent or greater value of biodiversity. I think that's...
Thank you. On that last criterion, point 3, so I'm just tracking through the various schedules of proposed modifications. From what you're saying, Mr. Lepage, that's a further sort of iteration of that wording. Have we seen that? Is that in version D now, or is it something that's likely to sort of come through to us?
No, it hasn't come through to you yet.
Okay.
I was waiting really to see, and I think the Sussex Wildlife Trust might have a comment they want to make on
Who
that.
I can bring in, is it Ms. Brooks?
Thank you. Throughout our representations, the 3 representations on the Regulation 19, we propose like-for-like compensation, and in our matter statement, as you will see, we further again would prefer to see like for like as opposed to fair. We feel that's too open to interpretation. The MPG and the MPPF is quite clear about betterment for biodiversity, and so like for like I think would set an equivalent or a better standard for biodiversity, and we think that would be the way forward for the policy. So if Crawley were to accept that position, that would be brilliant.
Okay. I mean, I'm slightly confused. I mean, that's the word as submitted. Isn't it fair? Sorry, like for like. So we're talking about additional wording potentially.
Yeah, I'm picking up the wording from the National Planning Policy Guidance. As a last resort, compensation is secured to ensure equivalent or greater value of biodiversity.
We've put that within our matter statement as a reference point. Yeah.
Thank you. I will afford the opportunity to Gatwick Airport if there's anything further they wish to say on that point, and just more widely any further points on policy GAP 1 that you wish to pick up, but I don't even want to pick up the criterion 3 point first.
Thank you, sir. Yes, I mean, we have a very simple proposition here. This is a planning policy, and we think the planning policy needs to deal with planning policy matters that are relevant to planning issues. We don't think compensation that is not mitigation, that is outside the balanced assessment of a planning application should be included within the planning policy. There are other mechanisms already in place, as been referred to, that address those circumstances. So we think the phrase compensation is inappropriate within the context of this policy. Thank you.
Thank you. So in terms of the soundness issue and the recommended remedy is to delete it would be Gal's suggestion that the references to compensation be removed from the policy.
That's correct, sir.
Yeah.
Thank you.
Just to clarify, that's both in relation to criterion 2 and 3, or was that just in? Yep, nodding. Yep. Thank you. And in terms of just the wider application, sorry, if I bring in Sussex Wildlife Trust again, please.
I'm not sure if I have the opportunity to come back on that point, but in terms of that, I would say that the policy point 3 does recognise biodiversity net gain within the first element of wording, and I think it's really important that we see that there's a clear distinction between biodiversity net gain and the mitigation hierarchy. So I think the point of the mitigation hierarchy, avoidance, mitigate and compensate, is a relevant point for that bullet point.
Thank you. Mrs. Lepage for the council, please.
Just reiterate that the MPPG wording uses the word compensation.
Thank you. And for Gatwick Airport again, please.
Thank you. So this is a small point on criterion 2 actually, is we would question, so where it says the adverse impacts of the operation of the airport on the environment and the health and living conditions of the local community. I mean, our view, as we've explained in our hearing statement, is that overall at the moment this isn't sufficiently balanced as a policy in terms of the approach it takes to consideration of impacts, both adverse and positive. So query whether adverse should be there, but also we don't consider that the reference to and the health and living conditions of the local community is necessary, because the impacts that are identified afterwards are environmental, and then it's subsequently those environmental impacts might have an impact on health and living conditions. But equally, insofar as the airport also generates, significant employment, it has a positive impact on people's living conditions as well. So we don't think it's appropriate to frame that policy in a way that suggests that there's only one-way traffic in terms of the airport's impact on health and living conditions.
Thank you. Mrs. Lepage again for the council, please.
I'd just like to reiterate and turn to paragraph 185A of the NPPF, which is looking at the effects of new development of and pollution on health, living conditions and the natural environment. That's what we're seeking to do to sort of, there are natural environmental issues, but also impacts on the local community.
And in terms of this policy and the sort of the final part 2 policy gap 1 has the cross-reference to the development consent order. I think we were at the time of preparing our matters, issues and questions before we received statements, sort of considering how things might kind of all fit together. I think we were mindful that the plan was submitted prior to the development consent order being submitted and accepted by the planning inspectorate. Whether that kind of final paragraph is sufficient at this stage to deal with matters and that were, in the event that were the development consent order approved, that would be appropriately left to plan review if it has consequences for plan making.
I think the wording is about DCOs in general, and obviously with a potential future southern runway there may be a further one beyond the DCO. I think what we are intending to suggest, obviously it's the examining authority and not the council that determines a DCO application, but we're suggesting that in responding to a DCO, those are the matters that will be taken into account by the council.
Thank you. I'll bring in Gatwick Airport, please.
So yes, we agree with the suggestion. I think that at MIQ stage that paragraph be deleted, but our position is that there should be a freestanding additional policy that requires the plan to be reviewed in the event that the Northern Runway DCO is confirmed, and that review would have to take place prior to the commencement of the Northern Runway development.
Thank you. Can you remind me again, Ms Sargent, if were the DCO application to be approved, the likely time frame for kind of first implementation?
I'm going to pass that question behind me. I was told last night, but I've forgotten. It's not particularly soon.
So in terms of the current DCO, if that were to be confirmed, then we'd be looking at commencement of construction in early 2025. And then the first operational year would be 2029.
So sorry, just remind me again what Gala seeking. So it's a review policy to coincide with first construction or prior to construction. That's not going to, I politely suggest that's not going to work. I mean, it seems to me that the Borough Council has obviously the requirement to consider a review every 5 years, and were the DCO approval to go through, presumably that would be one of the various factors that would inform whether the plan needed to be reviewed. I think we were kind of wondering at this stage whether it was appropriate for us to proceed on the basis of the plan as submitted. And I think there's general appetite in the room that we do, that there's no need to pause or kind of wait for that process. But in terms of this additional, should there be a specific policy within the plan triggering a review within a time frame? I don't know if the council has an instinct on what's...
I just simply don't understand why Gatwick should be in any different position from any other developer. Why should they have a plan review because of their planning permission? It just doesn't work like that. I just noted that a review would have to take place before Gatwick decided to implement its DCO, which is Gatwick acting as if it's planning authority, which is a theme I'm going to come back to in due course.
Sergeant.
I'm going to rise to that, sir, but could I just ask you to consider the obviously extremely significant implications in practical terms if the DCO is confirmed and then the northern runway is built out? I mean, it will have clearly enormous implications for the borough's needs in terms of employment, housing, transport. So from my position, from where I'm sitting, the need for review is entirely obvious.
Thank you. I've got no further questions of my own on policy gap 1 that we haven't previously raised within the matters, issues and questions, and nothing further I wish to kind of raise at this stage. Before we move on to agenda item, we've now sort of covered agenda item 3 as well. Before we get on to agenda item 4 and the approach to safeguarding, are there any further submissions people wish to make in relation to kind of the overall or the overarching starting policy approach through policy gap 1? Mrs. Lepage for the council, please.
Yeah, I'd just like to come back, I think, on that point on timing, so agenda item 3. And I think particularly the council considers the plan can be found sound ahead of the determination of the DCO. Gatwick themselves are saying it's a low impact development anyway. And I would just iterate some key points that the northern runway is not operational until 2029. There's a slow build up of air traffic movements and passengers which are only exceeding the main runway growth into the 2030s, by which time we would have had a new local plan review, but it would be required by then anyway. The surface access implications of the local plan and the DCO have been assessed cumulatively together, both by Gatwick and also by the council in our sensitivity testing, which is also part of this question. The Northern Runway project doesn't affect any noise sensitive allocations in the local plan in the Crawley Borough area. The DCO, as we understand it, meets all its needs for its operational infrastructure, including parking, as well as offices and some of the hotels, and it's making provision for the very significant highway improvements that are required. The housing need arising from the DCO doesn't exceed the standard method figure for Crawley, and anyway the travel to work area for the airport is much larger than the borough. And as we've discussed at length yesterday, the local plan already has a supply-led figure for housing, so its strategy couldn't change, even if a need figure was identified to be higher with the DCO. Affordable housing is a concern that we are flagging as part of the DCO process, but again, the DCO doesn't increase the need beyond the local plan need, just beyond what the local plan can plan for, given our supply constraints. And given the less likelihood of those in lower paid jobs being able to travel the longer distance to housing further away, we are seeking through the DCO process further consideration of the impact of that in the borough and how it may be able to be mitigated through the DCO. But again, that couldn't change the local plan approach, as we're doing all we can given the supply constraints and viability within the borough. The DCO also considers its employment needs can be met across a much wider area, and again the local plan is considering allocation of the only strategic employment site that we could allocate if safeguarding is to remain. So I think those are the key points I would just like to pick up on that. Thank you.
Thank you. Can I bring in, is it Mr. Walkden on behalf of National Highways?
Thank you. We'd like to make a point in relation to point 3, the time of the submission of the local plan and the concurrent DCO with it. We've been presented with sensitivity testing looking at traffic impacts on the road network with the DCO and local plan fully built out to the end of the local plan period. Now what this modelling has indicated is that there are potential mitigations required on the strategic road network and the local road network in the scenario that both are built out. But it just stops there. There is no further consideration of whether that mitigation can actually be delivered, what that mitigation is going to be, how you would apportion or allocate the costs to the DCO or to the local plan. And just like to say that the modelling that was undertaken was sort of high-level modelling in the first place, and it's something that ordinarily would have been looked at in more detail had it been part of the full local plan. So we feel that there are potential issues there which need to be considered further in the scenario that the two come ahead concurrently. Thank you.
Thank you. I mean, in terms of where we are, I mean, does the National Highways appreciate we're in an examination now? The hearings are due to finish in January as things stand, depending on where we are with potential main modifications and consultation on those. I think the council's anticipating being in a position to adopt this plan towards the middle of next year. I'm not aware of the latest detail around the DCO timetable. I think we're at a position where further the opportunity's been extended for people to be kind of registered as I've forgotten the technical phrase, but I'll call them interested parties as probably a more accurate phrase for the people who are going to.
Hearings won't start before February or March.
Yeah, I mean, is it National Highways' position that we should be pausing this plan examination or waiting for the two to come together, or that this is something that's potentially going to have to be sorted out sooner rather than later, potentially as part of the next plan review? Or I don't know if Mr. Forsdick wants to go in first on behalf of the Borough Council.
If that's all right, just I can't see why the cumulative effects of the DCO aren't a matter for the DCO, and therefore the mitigation that's required, in addition to what's required under the local plan, would be a cost of the DCO. That would be my immediate reaction.
What I'd say to that is that it's a scenario where both are considered concurrently, and that the additional mitigation hasn't been considered in full, and it hasn't been considered in the context of what needs to be allocated to the DCO and what needs to be allocated to the local plan. What I would say in terms of the timetable for the local plan is that this is only an issue if the two run concurrently and the two are consented concurrently. Should the local plan come forward first, then it's no longer an issue. So we don't really see it as being a showstopper and that something that needs to be delayed. It's not going to delay the local plan period, but it is potentially further work that could be done in the meantime before it is actually adopted to demonstrate that it covers all bases, and that if the two do come together concurrently in the coming months, that the work has been done to demonstrate that it is not an outstanding issue and that the plan can be found sound.
Just so I can be clear, Mr. Walkden, in terms of the additional work that National Highways would suggest would be needed for plan soundness, what do you? I appreciate you say that the sensitivity testing has kind of taken us so far. What's the next in your organisation, or on behalf of your organisation's view, needs to subsequently be done?
I think the work to date has been undertaken with what we call a strategic model, which is fine for when you're looking at impacts over a network, but when you're looking at junctions in particular, junctions in detail, it's the software is not particularly appropriate because it doesn't model what's happening in detail at junctions. And so therefore, the next stage would be to do some junction testing based upon the strategic model flows. And that would give us the answer that we need at this stage, whether mitigation is required or not. And if mitigation is required, then some work towards, well, what level of mitigation is required and what sort of cost would that require needs to be undertaken. And from our point of view, it is something that can be undertaken before the local plan is adopted. It's not outside those timescales.
I see other people now wish to come in on this point, so I think if I go to West Sussex County Council first, and then for Mr. Cross from Gatwick Green.
The sensitivity test has looked at the combined impacts and didn't indicate a particular need for a change to the mitigation strategy, but the principal impacts of the local plan versus the DCO will occur at different junctions on the strategic road network, with the DCO impacts being concentrated around junction 9, which serves the airport, and the local plan traffic principally joining at junctions 10 and 11, especially junction 10. Obviously, there will be some traffic interacting between the two, but that is a relatively small sort of proportion of the total trip generation of the local plan developments. Should it be considered necessary, it would be possible to do junction tests to double check the established mitigation designs, but really with the additional impact coming from the DCO, whereas we're here to discuss the local plan, I think that's principally an issue for the DCO to address.
Thank you. Mr. Cross, please.
Yes, thank you, sir. I'd just like you to draw your attention to the Crawley Transport Modelling Study, TNO2. On your document list, it's ES/ST/01W. At paragraph 1.3 of that report, the following words are used. The task has taken the modelled LPR, the Local Plan Review, Scenario 2, with sustainable mitigation, and added the DCO development trips and mitigation assumptions. It goes on to say, 1.4, the test has retained the Gatwick Green employment floor assumptions as used in the previous testing. In other words, to put it in English, sir, the test which has been carried out for DCO has been carried out in the full and explicit certainty of Gatwick Green coming forward and the development taking place. This has been actually added to by Gatwick itself, which in its transport assessment for its GAL DCO, and I quote, these have been, that is, the cumulative impacts of Gatwick Green, of Hawley, and potentially other developments, have therefore been considered in the uncertainty log as reasonably foreseeable and included in separate modelling runs and reported in detail in a transport assessment in Annex B, Strategic Transport Modelling Report, DocRef, all the rest. The simple point again here is that GAL itself has included the cumulative impacts of various developments in its assessment of its impacts on the highway network. It would be extraordinary if at this point in time, given that some of these impacts won't take place till post-2030, that we were able to define precisely and accurately the allocation of funding for any mitigation required as a consequence of those impacts. So it is both a timing issue and also at a strategic modelling level. The best we can say at this stage is that the plan and the infrastructure development plan is a useful guide to what will need to be done as time passes.
Thank you for that. I hope that's given everyone an opportunity to say what they want to say on issue 3. I've noted the position, the request from National Highways. I'll reflect on the further submissions I've heard from other parties in terms of the work that's been undertaken to date. We will be having a mid-afternoon break, but before we do, I'm going to start getting into item 4 on the agenda on safeguarding, given its relevance to this particular plan. In terms of the agenda, there was an attempt to kind of break it down into constituent parts. I appreciate some people may wish to try and look at the principle and the detail in terms of the principle and then Crawley's specific approach together. I think what I'm probably anticipating or would probably like to see done is for the council to sort of go first in terms of how it's looked at this issue and its basis for how it thinks the plan as submitted is sound and would meet the relevant tests, including at National Planning Policy Framework paragraph 106, and then the kind of the broad kind of nuts and bolts of how you've kind of looked at some areas which you've determined as being kind of critical, and then those that you have assessed or determined are not critical to be safeguarded within this plan. If I allow the council to do that first, we'll see where we are, whether we take a break, and then I'd like to hear probably from Gal next in terms of their submissions, and then I'll come to Gatwick Green, and then we'll see if there's anybody else, probably Mr. Keane on behalf of Ardmore, and then we'll see where the discussion takes us. So I wonder on that basis if I can invite, I don't know, it would be Mr. Forsdick or Mrs. Lepage, to really kind of set out the council's stall on this issue in terms of how you've looked at safeguarding and arrived at what you consider to be a sound approach in the very kind of specific context of the circumstances in Crawley and with Gatwick, please.
Okay, and can I just start by saying you'll know that we make a fundamental distinction between the land that is necessary for the runway and the surface level car parking to the east. And that's a fundamental distinction that will run through all of what I'm going to say now. Okay. Obviously, we all know that I've got quite a lot to say, I'm afraid, so, and I'll be picking up all of Gatwick's responses in their MIQs in my answer now. Okay. National policy obviously supports the principle of safeguarding for critical infrastructure. And the headline point, of course, is that any land that's going to be safeguarded has got to be shown by robust evidence to be potentially critical to the delivery of the nationally important infrastructure. It's a very high test. Second point is that national policy leaves the justification for any particular safeguarding and its extent to the local plan process. It is not in the gift of the airport as to which land is safeguarded and which is not. Third, if you wanted a legal obligation that was binding on the land and taking it out of planning policy, you'd seek a safeguarding direction. There's legal framework for a safeguarding direction. That's never been used here. It provides a legal obligation on the local councils vis-à-vis safeguarding. There is no such legal obligation here. It's a policy obligation to be executed through the local plan process. The next point is the role of the master plan. And we know from the documents, I'm going to principally refer to the Airport Policy Framework 2013, Aviation Policy Framework 2013, that the master plan has to provide sufficient evidence to inform, not to dictate, to inform the formulation of plan policy, to allow councils to give due consideration to the airport's plans in their local plan process. It is not, the policy does not make the master plan a trump card. It's a starting point for consideration. The closer the engagement and liaison with the LPA in evolving the master plan, the better. If it's effectively common ground and it's been adopted through a process and consultation and so on, then it's likely to be able to be taken from the master plan and put straight into the local plan. But the master plan is supposed to be where the local planning authority and this examination looks to find the robust evidence necessary to justify safeguarding. The airport at Gatwick here, their case is heavily predicated, in fact it is just replete throughout their representations, on the claim that the LPE, that this examination is, and I quote, it is not for this examination to seek to determine the extent of safeguarding. And that the council and user must follow the line that's been drawn on the master plan and never tested by anybody. That basic premise of Gatwick's position is simply wrong in law and rests on a fundamental misconception as to the respective roles of Gatwick as a private sector operator of a piece of national infrastructure and the local authority as the public face of local plan policy. Completely, fundamentally flawed misunderstanding of the whole scheme. Yet that basic case that GAL's red line dictates safeguarding, has dictated the whole of the approach of GAL to this issue. And they've basically said throughout, there's our red line, you've got to adopt it. It's just not simply incorrect. So, safeguarding policy, I'm going to make 4 points about safeguarding policy. First of all, in principle, the land has to be shown to be critical. And being critical, it's critical to the delivery of the nationally important infrastructure. It's not critical to allow GAL to sterilise excessive areas of land for its own long-term advantage. Secondly, the master plan is supposed to contain all the evidence. Thirdly, the better the master plan, the closer the alignment between the two. And fourth, absent robust evidence, the safeguarding will be unjustified. So in that context, I come to runway 2 itself, and I'll start to draw the distinction between runway 2 and the surface level car parking. The headline point is that we wish we weren't here in terms of the policy framework, but the position is, sitting here today, is that still the position in regard of future aviation growth post runway 3 at Heathrow has still not been determined. The Aviation Policy Framework 2013 remains the policy, and Aviation 2050 says it's prudent to maintain safeguarding for now. And so the Council accepts that the fact that the decision has not been taken by central government as to the future of aviation growth is itself, that the fact that decision hasn't been made is itself the robust evidence that the southern runway may become critical infrastructure. Hence the safeguarding of that. And in that, I think we're aligned with the interim inspectors, the informal inspectors visit a couple of years ago. So that's why we say that runway 2 itself should be protected, or the southern runway should be protected. The position on the car parking is completely different. The Master Plan 2019 is the current master plan, and so it has not a single word of evidence to justify the extent of safeguarding to the east for surface level car parking. So we've got to then look to the Master Plan 2014, and there's two documents which has been referred to in the papers. And perhaps you could just turn these up to see the paucity of the evidence base. To try to safeguard 138 hectares of land, a huge part of Crawley's area. Let's just see what the evidence to support it. So if we can go to document A5 in the Master Plan 2014, Operational Efficiency Master Plan. So if you're
once again, please, Mr. Fawcett.
It's PS EGSM GA 16.
Sorry, can I have that reference again, please?
Yes, it's PS EGSM GA 16, according to our index. I hope that's the right. The efficiency, efficiency master plan. Yes, A5 it should be called.
Yeah. Sorry. Yes.
Operational Efficiency Master Plan. It's quite a big document. You might not like the download. I think this is the first time anyone's taken you to it, so I would appreciate the opportunity to just show you.
Appendix A5, is that correct?
Yeah, A5.
Yep.
Yep. Okay. And it's page 35 first of all. You'll see there at page 35, that's the extent of the justification in this document. It's page 35, paragraph 3.7, 2050, you get to 97,500 car parking spaces, long stay in the column there. And then you see below that 35 hectares can be released for employment, just by a bit of decking, if need be, if Gatwick want to do that. Then if you go to page 91, I hope it is, you can see that there's just a huge block of surface level car parking to the, well, there's 4 blocks, I think, of surface level car parking, but the huge one to the east is the one I'm going to be focusing on. And you'll see immediately, so that basically is drawn by reference to either the airport boundary or the highways, and you'll see it goes right up to the M23 and it goes right up to the spur road. And so you'd expect to find somewhere here 97,500 or 97,750 car parking spaces need that much space, but there is complete silence on that as to how they justify 138 hectares. Then we go to A6, the next document, which is the it's included in the same document. It's so it's within the same zip file. It's document A6, surface access. Page 165. The only place where car parking is dealt with in this document. You'll see in the first paragraph towards the end, promoting a shift to more sustainable modes as part of the strategy. We'll see these themes. We'll see decking and mode share and multi-storey car parks and block parking as repeated themes throughout all of this. You see decking in the second paragraph, and over the page at 166 you see the summary of the 2012 ASAS, and then we get 9.8.2 is the car parking objectives for R2 ASAS, and you'll see straight away they want to have the associated benefits of consolidation in the second bullet, but third bullet, their objective for the R2 is making the most efficient use of the combined on-airport car park supply, including the impact on land take and impact of parking traffic. So most efficient is what they say is their objective. And we agree that anything less wouldn't be acceptable in planning policy terms. And then they talk in 9.8.3 as to future demand and how they're going to reduce demand through mode share shifts and so on. And then they look at how many spaces that will require. And if you go to the top of page 169, you'll see decking for the premium long stay parking, decking for the North Terminal long stay parking, potential decking for the long stay car parks. Page 169. And so we know that the R2, runway 2, is going to have an efficient use of land to deliver 97,750 car parking spaces, but we've got no link whatsoever from that figure through to the 138 hectares. There's no justification for the 138 hectares there at all. And of course, even Gatwick's own documents accept that within that 138 hectares, at least 35 hectares can be released for employment. So that's its own case. That's Gatwick's own evidence base. And they can achieve that, releasing 35 hectares, just by not my word, their words, some decking. So that's their policy position in the master plan. Then we need to look at developments on the ground. And I alluded to this yesterday, and so did my team. The developments on the ground are as follows. I mean, the headline point is that the council has been aware through 3 major inquiries at which GAL appeared that GAL was very substantially increasing car parking numbers through efficiency measures, through massive efficiency measures which it was promoting as being the way to go, and therefore to justify refusing planning permission for holiday extras and other sites off-site. In other words, they were saying, don't let somebody else take the juicy car parking traffic, we'll provide it on site. And that went through 3 public inquiries and a High Court challenge, which, as you know about, and Gatwick's position was accepted that there was huge scope for efficiency. That's the holiday extras inquiry. That could lead to vast increases in the amount of car parking on airport. And GAL never claimed that it couldn't viably deliver decking or block parking or machine parking or anything like that. Then we get the DCO, a huge, as we've just heard from Ms Sargent, a huge project, so we're now told, a potentially huge increase in passenger throughput, but only needing 1,100 extra car parking spaces because of the ability to deliver safe, more efficiency. And I showed you those documents yesterday, the 1,100. We can give the evidence on this if necessary, but in the DCO process, GAL also offered to provide an additional 3,300 so that the council could get rid of unauthorised off-airport parking and bring it on site. So they weren't saying any problem whatsoever with delivering all the necessary on-airport parking. And the takeaway point from what's actually happening on the ground is that Gatwick is telling us repeatedly in public forums, in public inquiries, that there is huge scope for efficient use of land to reduce the land take. And our simple and overwhelming point is that they haven't followed that through into the safeguarding. They've ignored all of that in the safeguarding. So we look at the safeguarding and we go, well, hang on, we can see why you need to save the runway and all the operational land for the runway and the taxi carriageways and the separation distances and all that. But why on earth do you need 138 hectares for surface level car parking? And we raised that question repeatedly with Gatwick in email correspondence before the before the Regulation 19 was issued. So we're being told by Gatwick we never raised it with them. It's simply factually wrong. We raised it with them repeatedly, and they said, master plan. You've got the master plan red line. Stick with that. And so we didn't have any answer to it. We thought that there was ample justification for relaxing it to allow us to then meet our employment needs through the Gatwick Green site. Right. Then we get the ARUP report, and we considered, the officers alongside me considered that it wasn't remotely robust because it was simply flew in the face of what we were being told in public inquiries, where promoting efficiency was in Gatwick's interests. It simply didn't compute that you needed 138 hectares of surface level car parking. We didn't have to then do much more work because ARUP assessment was then subject to the critique by Mott MacDonald, which basically told us everything that Gatwick had been telling us in public inquiries. So there was huge scope for improvements in efficiency through mode share, through the efficient use of land, through decking, through block parking, through machine parking, just as Gatwick was telling everyone was going to happen in the real world of the DCO. And rather than face up to the argument and come back and say, well, actually, we think we need 100 hectares or 60 hectares or whatever it was, GAL never responded to the MacDonald report. they had ample opportunity. I can't remember when it went in. I think it was May or something, but ample opportunity to respond. And even in their MIQ answers earlier this month, there wasn't a single word of answer, I think, to the Mott MacDonald. And so we then come to the ARAP report, and well, I don't have to rely on York to get to these criticisms. It's self-evidently based on multiple flaws, including one of the most obvious is it doesn't count off-airport lawful car parking. Why on earth are these off-airport operators going to give up very valuable rights? And I think that accounts for about 21,000 spaces, so a huge overstatement right at the beginning of their assessment. But the problems with the analysis are dealt with it by Mott MacDonald and by York. And so the result is this. This is where we get to, as a matter of soundness. The council is working within a highly constrained land supply situation, and that is the overwhelming basis upon which every other part of the plan has to proceed. We're stuck between a rock and a hard place, so every other part of the plan has to proceed on that basis. GAL has recognised the need for the car parking to be an efficient use of land in Master Plan 2014, but then it seeks to safeguard 138 hectares for effectively surface level car parking without any of the efficiencies that it's actually in the real world relying on. And we say, just as a matter of basic principle, it's impossible to find, as a matter of just rationality, it's impossible to find that there's a critical need to protect surface level car parking land in the national interest. It's just a complete non sequitur. And therefore the case for release of a substantial chunk is overwhelming. And we've taken the view that meeting our needs and having a strategic environment, a strategic employment location is the way to go. You may come to a different view as to how much to be released and where the evidence settles down. But we have not seen a single word of justification to even start to explain why you need 138 hectares or why 89 hectares is not enough. So I'm sorry to go on, but that's what I was instructed for. That's why I'm here, so that's my 2 pennies worth.
Thank you. No, that's very helpful. What I'm going to do though now is to take a brief mid-afternoon adjournment. And as indicated a short while ago, once I've heard from the council's position on safeguarding, I'll, after the break, come back and hear in this order from GAL next, then from Gatwick Green, and then I think it's for Mr. Keane for Ardmore, and there may be others who want to come in on that point. We'll see where we get to in review of the agenda. I should have said at the start of these afternoon sessions, we're generally trying to finish about 5 o'clock each day. We've got a bit of flexibility on that, but not much. So we'll see where we are, and we'll look at timetabling if we need to. So what I'm going to suggest is we have a 10-minute break now. It's 3:45, so if people could be back in this room, please, at 3:55, and then I'll next hear from Gal on the issue of safeguarding, please. Thank you.
nice checklist of things that, you know, we want done better.
Yeah, thanks.
zooming to us off the telly.
Yeah.
Where is she? Didn't see where she went. Did she go out the side door to come in the back? Where is she?
Okay, I'm going to start.
Sorry.
I'm going to start. Okay, it's just come up to 5 to 4, so I would like to resume this afternoon's hearing session, please. Okay, and before we took the brief mid-afternoon adjournment, I'd obviously heard from Mr. Forsdick setting out the Borough Council's position on its agenda item 4. We're kind of largely taking A and B together, or the first part of B together. I'm going to afford a similar opportunity in the first instance to Gatwick Airport in terms of its position and submissions on the approach to safeguarding in this plan, and then I'll cascade to other people who've made representations on this. So I don't know, it would be Ms. Sargent to introduce for Gatwick.
Thank you, sir. Now, in view of the fact that the council accepts that there should be a safeguarding policy, and as I understand what Mr. Forsdick was telling us before the break, it agrees that safeguarding is still part of national aviation policy, but its view is that the Gatwick Green site can nevertheless be removed. I'm not going to go back over what GAL has submitted. This is Appendix 2 to our hearing statement. You'll have seen we went through the policy chronology and history in some detail in that note. So I'm not going to go back through all of that, but I am going to begin with paragraph 106C of the NPPF. And before I come to that document, the first observation I want to make is that we looked at that zip file before the break, which was PS EGSM GA16. Those documents date from 2014, and obviously that date, I'll come back to the reasons why this is significant, but 2014 is of course before the inspector's report on the 2015 local plan, and I'll come back to that point later. But the reason that I mention 2015 and the current version of the local plan is that paragraph 106C is not new. It, in substance, albeit the wording is not identical, but the substance of what it says was in the NPPF from its inception in 2012 at paragraph 41. And I would like us just to see what the response to paragraph 106C was from the council last time this issue of how safeguarding in the local plan should be addressed actually was. So looking at the current, so the December 2015 local plan for 2015 to 2030, in the supporting text, beginning at 1.38, the situation is explained at that point in time. It wasn't certain or known whether there would be a second runway at Gatwick or not. So the options were outlined as either we have a second runway and then potentially the safeguarding is lifted, or we have no second runway but safeguarding is lifted, or we have no second runway and safeguarding continues. And obviously it's the third of those options that eventuated. But says when you look at 138 through to 1.42 of the supporting text, it's clear that the council's view was that if there wasn't a second runway but the safeguarding remained in place, then that would have to be respected, and that employment land in that situation would only come forward outside the safeguarding land. So in 2015, the anticipation, if we ended up in a situation that we have ended up in where we don't have a second runway but we've still got the safeguarding, the council's view was that, you know, that's tough and safeguarded land is safeguarded land and you can't put any employment land in it. And at 2.7 of the supporting text, similarly, it says the physical constraints that mean that the town's, this is Crawley, anticipated housing and employment needs cannot solely be met within its own administrative boundaries, particularly given the current safeguarding parameters and the uncertainty over growth at the airport. There are far too many other similar references in the current plan for me to work through all of them. But the overall approach is clear, which is that when the current plan was adopted, the view was that until the government had decided whether or not the safeguarded land should stay safeguarded, then there was not to be any employment land within the safeguarded land. And we can see that from policy EC1 itself, actually. Where the final paragraph says the preferred location for strategic employment is within the borough to the north of Manor Royal and south or east of Gatwick Airport. However, given current safeguarding for a possible second runway, work required to identify an appropriate site or sites will take place after the government has issued a final decision on additional runway capacity in the UK and has determined whether the area should still remain safeguarded. And then at paragraph 525 of the supporting text, sorry, 523, it says that if following a decision on the location of additional runway capacity, the current area of safeguarded land is retained and employment needs can't be accommodated within Crawley, then the council will continue to work essentially to investigate the opportunities to bring forward that land in the areas adjoining Crawley and Gatwick, and if that can't be done, then they'll look further afield again. And so in the airport submission, that's the appropriate response, which was to acknowledge that if the land remains safeguarded, which it does, then we need to look outside of the safeguarded land to accommodate employment needs, and if that means that they have to go into neighbouring areas, then so be it. That, of course, is not what the council has chosen to do this time around, but I do also want to just pick up the inspector's report from the 2nd of November of 2015, and the reference for your note is paragraph 78, where the inspector is talking about potential employment land, but land that lies within the safeguarded area, and his view is that there is no realistic prospect of bringing this land forward in advance of the government's decision on airport expansion. And if I could ask you actually to turn up the inspector's report, which is CBLP 03, and go to paragraph 80. You'll see the inspector is looking at sites not allocated in the submission plan, and he's considered the contention that because it's not directly required for operational uses associated with a second runway, the safeguarded Gatwick Green site to the east of Balcombe Road should be released now for employment development. And the inspector's view was that it may be, as the promoter apparently argued, that the large area of surface parking for which most of this land is provisionally identified in the Gatwick Master Plan represents a suboptimal use of land given its scarcity, and that decked parking could free up land for employment uses. However, the safeguarded land has been identified for many years, it's endorsed by the Civil Aviation Authority, and there's no compelling evidence to suggest that it would not all be required should a second runway be built. As the core strategy inspector remarked, it's difficult to identify on a contingent basis the precise area of land required for such a complex major project, and it's not unreasonable to include some flexibility, even if not all the land is ultimately used. So his view was that the evidence on safeguarding was robust and did satisfy the could-be critical test of paragraph 41 of what was at the time the 2012 MPPF. Now, of course, I don't suggest for a moment that you are bound to take the same approach as the inspector did in 2015, but the airport's submission is that everything that is said there remains accurate, and in particular, there is no compelling evidence to suggest that not all of the safeguarded land would be required, and I'll come back to that point shortly. But as we know, the approach taken in the plan in 2015 was found to be sound, and that includes against the definition of soundness in the 2012 MPPF, which at that point, as now, had a requirement of consistency with the MPPF. And I'm not aware that there was any successful legal challenge to the inspector's stance that I just described. And all of this, of course, is coming after the 2014 documents in the zip folder that the council is now so critical of. And then, as I went to, but I think to a different reference, earlier today we had Mr. Ball, his indication in 2020 of the approach that should be taken by the council. And I note that he says this is on page, I don't think it's numbered actually, but it's under heading 6, Gatwick Airport and Safeguarded Land. At this point in time, the council was trying to get rid of all of the safeguarding, as I understand it, and Mr. Ball's view was that that policy was unlikely to be effective given the national policy position, but also under the heading 9, Employment, Mr. Ball said he'd suggest that the policy situation is not the same now as it was when the current local plan was examined, because the MPPF says that local plan policy should positively and proactively encourage sustainable economic growth. But his view is that with the safeguarding of land still in place, the council should be proactively seeking to accommodate unmet economic needs in nearby authority areas through the duty to cooperate. So again, in 2020, although Mr. Ball's view was that the policy situation had moved on since 2015, he didn't suggest that part of the safeguarded land could be taken forward for employment land. His view was that we had to look to the duty to cooperate. So there is, in my submission, no justification for the resurrection of the suggestion that it is sound for the council without having discussed this with Gatwick. I'll come back to that in a moment. But there is no justification for the resurrection of the unsuccessful suggestion from last time around that not all of the safeguarded land actually needs to be safeguarded. And turning to whether there is robust evidence to satisfy paragraph 106, in my submission, part of the requisite robust evidence that the safeguarded land could be critical is the fact that it is safeguarded as a matter of current national policy, and the council does not dispute that. So I don't agree that when we look for robust evidence, we just look at the airport's master plan and at nothing else. The fact that the safeguarded land is safeguarded as a matter of national policy is plainly, I would say, a significant part of the requisite robust evidence. We have to remember paragraph 106 is not just talking about airport safeguarding, it's talking about infrastructure delivery much more generally. Then, of course, there is the airport's master plan that was consulted upon. And as one would expect, the airport isn't trying to be the local planning authority here, but it and obviously it alone is the body that actually operates the airport. And unsurprisingly, it has considered very carefully indeed where the safeguarded land boundary should be. And that consideration is evidenced in the documentation that you have. Just to take an example from the 2019 master plan itself, at 5.4.12, it explains that essentially the safeguarded area has been revised because the initial extent of the land was based on a much earlier scheme developed by BAA when they were the airport owner. And as we've explained in the hearing statement, in the course of preparing the proposals for the Airports Commission, Gatwick looked again at the boundary for the safeguarded land, and it's explained at 5.4.12 that to meet operational requirements, it's been found necessary to make some adjustments. There's also, as we've explained in the hearing statement, the Airports Commission's conclusions on the work that Gatwick had done. As we've set out in Appendix 2, the Airports Commission recognised explicitly the quality and the quantity of the effort that had gone into that submission. On top of all of that, you then have from 2021 the technical work from ARUP, which we resubmitted as Appendix 5 to the hearing statement. I'm not going to respond this afternoon to the criticism of ARIP from the council, because that is a matter that's covered in the York aviation note, so we'll be responding to the content of that note in writing. So that's where we say the robust evidence is. Turning to the council's position, it doesn't contest the continued application of safeguarding in principle. It just wants to take Gatwick Green and only Gatwick Green out. We don't have any record of, I'm instructed that we don't have any record of any correspondence from the council. If I've missed that somewhere in the examination library, then we can go to it, but I'm awaiting that reference. The more important point, though, is that it took the council more than 2 years to produce any technical work of its own in response to the ARIP work, which is the York aviation note. And then the council said just now we didn't have to do much because Mott MacDonald did it for them. Well, again, Mott MacDonald's work was submitted in June of this year, and I'm afraid that just won't do. The council was told in late 2015 by the local plan inspector last time around that safeguarding had to stay and that Gatwick Green was a no-go. So given that indication, it should have provided technical supporting evidence at the Regulation 19 stage to support contemporaneously its proposal that actually Gatwick Green can be removed now. It didn't do anything for 2 years. And then there was reference to the airport having acknowledged the need for efficiency. Well, first of all, it's unsurprising that the airport should seek efficient use of land, whether that's for car parking or for anything else. But in supporting the council taking enforcement action or refusing off-airport car parking, the airport's point was not simply one about efficiency, it was also making the point that it's more sustainable to have car parking within the airport boundary and to transfer passengers using the on-airport road network. So it's true that the airport did outline what it was trying to achieve in terms of efficiency measures, but that related to products that attract a premium price close to the airport, and it's not correct to suggest that, you know, for Gatwick this is only about efficiency and nothing else. There's a clear sustainability argument here as well. So that's what we have to say by way of sort of outline and a summary of how we say that section 106C, paragraph 106C is satisfied here.
Thank you. Before I bring in others, is there anything specifically Gatwick wishes to say in response to the council's points and from what I was certainly sort of inferring from Gatwick Airport's written submission, that this is almost an issue we can't go to or can't look at because it is set out elsewhere in national policy, that safeguarding is not an issue for us to kind of effectively examine, or as Gatwick's position shifted on that, and safeguarding is something we look at, and we look at it through a number of things, but paragraph 106C.
I think the end result doesn't matter, sir, and I hope for the reasons that I just outlined. If it is something that you are to look at, then we've explained to you why the answer is what we say it is. I know that the government's view, as expressed in its policy documents, this is in our Appendix 2, is that there is sufficient guidance in paragraph 106 essentially to enable everybody to get on with things at local plan stage. Personally, that's not a view I share. I don't think paragraph 106 is sufficiently clearly drafted. But equally, I acknowledge that last time around, the inspector did, at least in a paragraph or two, turn his mind to whether paragraph 106 was met or not. So certainly whether or not, I think it's difficult. It's clear that whether or not safeguarding at Gatwick remains in place is a matter for the government, and that seems to be something that's common ground between the airport and the council. So for my part, I struggle to see on what basis actually local plan inspectors do kind of look behind the curtain and start turning their minds to whether chunks of safeguarded land can not be safeguarded anymore in the light of a government position which is that land should remain safeguarded. But I acknowledge that last time round this is something that the inspector did look at briefly. So for that reason, I've addressed both aspects of the argument.
And am I right in understanding this is an issue that is unique to Gatwick? I mean, the only other reference I've read in all the background reading is to Edinburgh as another airport that has safeguarding. So I say unique in an English sort of context.
No, I'll have to find the reference for you, but when I was rereading through things yesterday, there is a reference somewhere that says many, or I can't remember the exact wording, but many or several airports do have safeguarding. So I'll try and find that reference for you, sir.
Thank you. I've made various notes there. I think the safeguarding discussion will continue, but it will continue immediately. I think I indicated for Gatwick Green for Mr. Pereira in the first instance, please.
Thank you, sir. And then if you, well, we will then bring in Mr. Mayor to address some of the ARAP material and the car parking justification. So I've got 5 headings I want to make my points under. We agree with what Mr. Forsdick has said, just by way of overview, and the Council's position. So the first heading is the quick summary references of our position you can get from our hearing statement for matter 5, 2.1 to 2.7. And obviously here the question is not one of principle but one of extent. The plan supports the principle of safeguarding, the debates around the extent. Second heading, GAL's position is extreme. Mr. Forsdick gave some references. I'll just read another one. It's from their hearing statement, page 5, paragraph 2.4. It is the duty of CBC to reflect the extent of land that is needed to be safeguarded as set out in the 2019 Gatwick Airport Master Plan. That's a brash submission, and it's worth just letting the brashness of it fully sink in. It's saying that even if you consider safeguarding across Gatwick Green is unjustified, even if you consider that Crawley would be best served by strategic employment at Gatwick Green, you are powerless against GAL to do anything about it, as though the 523 hectares has become fossilised into the plan and future iterations of the plan until Gatwick tell the public that that's no longer to be. So it's an extreme and, I do say, brash submission. Next, third heading. GAL's position is wrong in law, and we agree with what Mr. Forsdick said. The basic position is national policy supports the principle of a safeguarding policy and defers to local planning authorities and plan makers to decide what, if any, safeguarding is justified. And I want to pick up on the policy references that GAL refer to in their hearing statements. The first is the 2003 Air Transport White Paper. That was withdrawn in March 2018. It's not relevant anymore. But, and we've pointed this out at paragraph 2.7 of our hearing statement, it contained a plan which appears to have been used as the basis of GAL's safeguarding plan, which was expressly described as being indicative and expressly described as not to be taken as a safeguarding map. That appears to be the origin of GAL's safeguarding, but it was never meant to be and was said not to be a safeguarding plan. We've given the references. It's at para 2.7 of our hearing statement. And the white paper made it clear it was for operators to justify safeguarding. The main policy is, of course, paragraph 106 of the framework. And this is the only forum where the question of whether there's robust evidence to justify safeguarding can be examined, because that's what paragraph 106 is about. It's about what policies go into plans. There isn't any other place for this to be done. Importantly, all relevant higher level aviation policy defers to the framework. All relevant higher aviation level aviation policy defers to the framework. So the 2013 aviation policy, page 74, para 5.8, refers you to the MPPF. Aviation 2050, paragraph 3.66, refers to the framework, para 106, as providing guidance to planning authorities when developing local plans. So again, it differs. And can I just say something about that? It's important when we say that national policy supports the principle of safeguarding. It does not anywhere require safeguarding to continue. Paragraph 3.66 of Aviation 2050 says it is prudent to continue with a safeguarding policy. It does not say that the government expects safeguarding to continue or that it must continue, merely that it's prudent for that to happen. And that prudence has been exercised by the council here, but it would have been open to the council to say, we're not having safeguarding anymore, we don't think it's justified, and that would have had to have been something to be disputed following the rubric of paragraph 106. And it couldn't be said that was contrary to national policy. One might say it would be imprudent to use the term in national policy, but not contrary to national policy. But anyway, the prudence has been followed, and we don't dispute that. The next heading, which I think is my heading 4, perhaps. There is no robust evidence to justify safeguarding here for surface parking. We agree with the council that the place you're expected to look is the master plan, and not to look at it as Gatwick would have you do, with an attitude of deference or subservience to what they say, but to look at it in the role that you perform here, which is of an examining authority appointed by the Secretary of State to scrutinise the soundness of the plan. And so you do that by asking, as per para 106, is there robust evidence to justify the safeguarding? And it's quite striking that GAL in their response don't respond to the very specific and detailed points that Mr. Forsdick made in his representation about what GAL actually say in their master plan and what they've actually said in their DCO, but instead seek to divert you away from the detail to a kind of general point that this is what's happened before, so it should happen now. So I want to respond to a little bit of what Ms. Sargent's said. She said part of the robust evidence is that it's safeguarded in national policy. Well, it's not safeguarded in national policy. National policy says it's prudent to continue a safeguarding policy. There is no national policy specifically safeguarding Gatwick. It doesn't exist. The only safeguarding policy is in the local plan, and now the emerging local plan. And of course that's a bootstraps argument, well, because it's been safeguarded in the past, therefore there's robust evidence to safeguard it now. We must look at the circumstances now. A few points about the evidence. So Mr. Mayor in a moment will speak to the Arup paper, but I think it's important you realise the Arup paper has not been put forward by GAL as the work that underlines the 2019 master plan. We haven't seen any work for the large areas of surface parking under the 2019 master plan. in Gal's Reg 19 representations on EC4, it's paragraph 20, the ARUP work is referred to as a review. It's not contemporaneous, it appears, to the master plan. Indeed, it's dated 2021. So we just don't, we have an evidential void as far as the master plan is concerned. And it may be that this reflects a difference in perspective, or everyone here understands why GAL would come to protect its own private interest. But the council's obviously acting from the perspective of the public interest and the needs that mean to be served, and we're, as Gatwick Green, keen to be a part of that. You and your colleagues may have noticed that every time you sit down there, you sit next to the council's motto, which says, I grow and I rejoice, and the lead councillor for the planning echoed that yesterday. Perhaps that's a digression. So that's one matter. ARUPS doesn't seem to be contemporaneous with the master plan. Another point, you're not bound by previous decisions, obviously, of the 2015 plan inspector. Ms. Sargent accepts that. The context of that plan was that the government had not at that time made the decision on which airport would be favoured for meeting additional capacity in the southeast. It was, we know it was then decided that it would be Heathrow. And that's really the context of that decision and the reason why it seemed particularly important to hold on to safeguarding then. And that's changed. Another aspect of the evidence that's important is that just the safeguarding must be in the public interest. And as we've said in our hearing statement, there's a countervailing public interest here, which is the need for employment land. This is paragraph 2.5 of our representations. And so the robustness of the justification from GAL does need to be seen against the counterweight of the public interest in allocating the land. That's also different from the 2015 position. We now have more commonality on the needs for employment. A third point on the way you might look at the evidence, the 2013 aviation framework, it's at B1 and B5 of that document. It's quoted at paragraph 2.2 of our hearing representation. It makes it very clear that safeguarding should minimize long-term uncertainty and non-statutory blight. And goodness knows there's been plenty of uncertainty here for a long time. But the importance of that, sir, and to your colleague, is that it gives you a steer on how you see the evidence, because it lets you know that the expectation of policy is that the extent of safeguarding should be minimized. And that, it's obvious why. It's because it's a constraint on the normal exercise of private landowners' rights. So the extent should be minimized, which is why it's important that robust justification comes forward. And finally, on the way you might look at the evidence, sir, your function, unlike the 2015 inspector, is to decide whether this plan, without safeguarding over Gatwick Green, is sound. The 2015 inspector was considering a different plan with safeguarding and asking whether that sounds. So the starting point is this plan, which the council say is sound, and you're scrutinising that. If you're going to make a change to extend safeguarding over Gatwick Green, you must conclude that that is sound. And to do that, you must ask yourself, well, what's the evidence to justify it? And from my client's perspective, sir, it would not be sound to extend safeguarding over Gatwick Green, not simply because of all the problems that would cause in the positive planning for employment needs, but more simply because there isn't the robust evidence to justify safeguarding being needed for surface area car parking in that place. So that's what I wanted to say by way of overview and approach. Can I ask Mr. Mayor to step in and deal with the specific parking matters? Thank you.
Thank you, James. Thank you, sir. Yeah, I don't want to repeat information that we've just heard. There's been lots of good points made from our colleagues in CBC, around the table from James himself. So I'll try and just add a couple of points that sort of add to what we've already heard. But as a first point, we agree with everything that we've heard so far from CBC. On the point of evidence, there was just a couple of things that I wanted to pick up on. I want to cover three topics actually: evidence, demand, and supply. On the point of evidence, a couple of points that I think are worth considering is, firstly, the 2019 master plan refers back to the safeguarding land originally being defined by the previous airport owners, BAA. I don't think we can consider that to be evidence, because that's simply referring back to a predecessor, but not providing any of the work the BAA did to justify the safeguarding land in the first place. So that doesn't seem to be evidence from an airport planning perspective. The short section looking at the wide space southern runway also refers to a plan, Plan 21, within the 2019 master plan, and Plan 21 provides an image of the safeguarded land for car parking. Interestingly, it's a sort of an isometric illustration, a sort of a bird's eye view, if you will, that appears to show surface car parking. It's not necessarily representative of surface parking, but it's definitely an artist impression, and I don't think any of us would consider an artist impression to be evidence either. And lastly, on the point of evidence, where the 2019 master plan is lacking, the ARAP paper has referred back to the work that was done earlier and submitted to the Airports Commission back in 2014. Interestingly, and I believe this point was touched on earlier, the 2014 submission includes a table that describes how many car parking spaces are required. The figures in there, as we've heard, are 95,750 car parking spaces east of the railway line. So that's all the long stay and staff car parking. That doesn't include the short stay parking, which takes the total up to 104,000 spaces. Now, that table is just stating a demand. But again, a stated demand is not evidence. It doesn't say where those figures have been derived, how they've been calculated. And so, we can take that table at face value, but the question that we want to ask is, where's the work that underpins that table? There should be detailed analysis that could have included all sorts of things. It looks at mode share, it looks at traffic forecasts, growth of passenger numbers, that would look at what's the average dwell time of car in a long stay car park? Is it 2 days, is it 2 weeks? All of that evidence, all of that analysis that would underpin that table wasn't provided to the Airports Commission in 2014 and hasn't been provided since. So at the moment we have a table that we're being asked to believe in, but without anything to explain where those numbers in that table have come from. So that's the evidence point. The second part is around demand. Demand is interesting. Let's assume that the numbers in that table are correct, and the figure we're looking for here is 95,750 car parking spaces in total. The number doesn't seem to stack up when we compare it with other documents that have been published by Gatwick Airport. We can compare the work from 2014 to the work that's existed in the more recent publications, the 2019 master plan, even the DCO submission, and there are inconsistencies between them. So for one thing, as pointed out by CBC, the 95,750 doesn't mention the fact that there are in the order of 20,000 off-airport approved car parking spaces that form a part of that 95,000. So 20,000 car parking spaces is obviously a huge number, significant amount of land, but that wasn't mentioned in the submission to the Airports Commission, so hasn't been considered within the ARAP paper. So that's the biggest sort of number that we are asked to question. There are other elements in there that are also perhaps questionable. The fact that the 2014 work is out of date is apparent in the number of short-stay car parking spaces. It assumed that there were only going to be 5,000 short-stay car parking spaces serving the south and north terminals, and with a third terminal being added, there would be another 3,500 spaces added to serve the southern terminal. That might have been true in 2014, but it's not true today, because since then, GAL have used permitted development rights to develop 2 new multi-storey car parks adjacent to the north and south terminal, which means the current number of short-stay car parking spaces is in the order of 9,400. And when you add a further 3,500 to that for the new terminal, we would be looking at over 12,000 short-stay car parking spaces. And the point there is that the more short-stay car parking spaces we have, the less long-stay spaces we need, because the total quantum of car parking spaces remains finite. And similarly, there are questions to be raised around the number of staff car parking spaces. The trend there is that that's declined over the years from 7,000 originally down to 6,200. That submission to the Airports Commission suggested that would jump all the way up to 12,000 car parking spaces, which belies the trend of staff mode share shift, and doesn't seem to recognise that all of the growth recently has been able to grow without providing additional staff car parking spaces. So there's a sort of perhaps 3 parameters there that seem to be inaccurate, giving us perhaps a false figure of demand. And where we take all of those into account, we believe a more realistic number of car parking spaces for the land east of the runway is in the order of 65,000 spaces. So that's the demand point. And finally, supply. Supply is also quite interesting. We know that the total amount of land available east of the railway line is 138 hectares, which is a huge amount of land, to say the least. If all of the car parking spaces had to be surface parking, then you might try to argue that that entire extent of land would be needed. But we don't believe that that is the case. There's a couple of reasons. One is that within that table from the 2014 evidence, it describes that 24,000 of those long-stay car parking spaces could be block parking. So that wouldn't be conventional car parking layouts where you've got aisles between spaces, lots of room for drivers to circulate. That's a much more spatially efficient and dense parking arrangement. And there's just a simple calculation there. You can take that 24,000 spaces, which is also a huge number, and look at the effective area that would have comparing it as conventional parking compared to block parking. And the block parking being more efficient by not having those aisles needs a lot less space per car. You multiply that up and it gives you a saving of in the order of 12 hectares. And 12 hectares is a huge amount of land. I was sort of thinking this morning, how do we relate to that? How do we give that sense of scale? And the best example I could think of was that we're all familiar with the experience of, say, standing on the edge of a football pitch and thinking that other set of goalposts look like they're a long way away. A football pitch, quite often used as an example of chunks of land, is less than a hectare. You look at Wembley Stadium, which we all think of as a very big building, it's only 7 hectares. So that 12 hectare saving just by going to block parking, you could put Wembley Stadium in that and there would still be 5 hectares left over. So that gives us a sort of sense of scale of the sort of order of magnitude and numbers that we're talking about. So that's just sort of part of this. The last 2 points to make quickly is the ARAP paper said that more intense parking was a limited option for 2 reasons, both of which we believe are not true. Firstly, they described a height restriction. The height restriction they described is that there was the safeguarded surfaces associated with the airport is regulated by the Civil Aviation Authority, and they said it limits the height of parking to just one deck above ground level. That happens to be true if you're standing at the railway line. It's nowhere near true if you happen to be anywhere near the middle of the 138 hectares or over towards the M23, where the height restriction climbs as you get further away from the runway, and you could accommodate up to 7-storey car parks by the time we get to the A23. So the idea that we couldn't provide more intense car parking forms because of a height restriction based on regulations is not accurate. And finally, there was a question around the commercial viability of providing multi-storey car parks as a long-stay parking product. The premise being that they might cost a little bit more to build than surface parking. Firstly, that's not necessarily the case. It might be that there's more concrete involved in building a multi-storey structure, but you have to purchase less land. And compulsory purchase order of land costs money. So there's factors that can offset the capital costs. There's environmental impacts, there's drainage considerations, there's lots of financial elements to that as well. But if we look at whether there are any examples of whether multi-storey car parks are commercially viable, we've got 2 benchmarks in recent history in comparable airports. In Heathrow's DCO application, for the 3rd runway, they went through 2 public consultations. Their proposal was all of the long-stay car parking would be multi-storey. And their reason for that was that they didn't want to compulsory purchase more land than they needed, displacing people from their homes, farmers' fields, playgrounds, other land uses. So they were going for a more intense form of car parking. And that was what they were committing to in their development. The other example, perhaps even more relevant, is a real-world live operational example, which is Manchester Airport, which has already implemented multi-storey car parks and is using them for a valet parking product, which incidentally is more efficient than the long-stay surface car parking and is also making more money. So thank you for your attention. That was all the points I wanted to make.
Okay, thank you for that. I'm going to draw a line there on sort of Gatwick Green's submissions at this point, because I do want to hear, before we potentially close for today, from Ardmore Land, Ardmore Limited. I suspect, is it going to be Mr. Keane?
Yes, sir.
I suspect this is a slightly different view on the kind of the wider principle of safeguarding, notwithstanding the council's submission that they think they're adopting a sound approach. So I'm expecting to hear new things.
I'm grateful, sir. Thank you. And I can adopt some of what's been said, and I'll try and do so along the way. But you're right, sir. And as you know already from the submissions that have been made on behalf of Ardmore, safeguarding, we say under GAT 2 is not justified, and it unnecessarily constrains land supply for the borough. I referred yesterday, sir, to us being 8 years on from the last local plan, 15 years on since the land was safeguarded in the core strategy, yet the position still remains ambiguous, effectively blighting suitable sustainable development land and seriously constraining supply. And as I said yesterday, so that's a point that's expressly acknowledged in the Council's topic paper 2, I think the reference 2.3.4 from memory, I gave it to you yesterday. So in that context, it's not sufficient, we say, for GAL to simply point to the 2019 master plan and say national policy requires safeguarded land should remain safeguarded. It's common ground, sir, that an airport master plan does not have development plan status. And when we look at what national policy does say, I can take this more shortly because you've been referred to it by others, but Para 5.9 of the 2013 government's airport policy is the high watermark, if I can put it that way, because that's the para passage, and there is another one I think in the document, but that's the one that says land outside airports that may be required for airport development in the future needs to be protected against incompatible development. And then it goes on to say, sir, until the government has established any relevant policies and proposals in response to the findings of the Airports Commission, which at that point was due to report in the summer of 2015. I'll come back to that in a moment. But so that's the only, as far as I'm aware, adopted national policy document that specifically refers to safeguarding and says it may be required in those circumstances. So there's a very helpful appendix 2 to the GAL submissions. I don't ask you to turn it up, that summarises the relevant policy extracts of these documents. But so next, I just want to draw attention briefly to the 2018 Aviation 2050 consultation document, paragraph 3.66. Again, it's been referred to earlier, and that's the passage I think that Ms. Sargent was referring to when she said she checked, but this is the one that starts, several airports safeguard land for future development. So it's not just, I think that was the point she was alluding to, it's not just, thank you, it's not just Gatwick and it's not just Edinburgh, but this tells us several. I don't know, I can't give you any more details, but there are others. And this is the one that says, as we've just been drawn attention to by Mr. Pereira, it's prudent to continue with the safeguarding policy to maintain a supply of land for future national requirements and to ensure inappropriate developments do not hinder sustainable aviation growth. But so that same passage goes on to say that it's the MPPF, and I know it's changed since then, but not substantively, but it's the MPPF that has restated the government's commitment to identify and protect where there is robust evidence, sites and routes that could be critical, etc. But so then this passage in the aviation consultation document then goes on to say the government believes that the MPPF, provides sufficient guidance for local authorities to consider the future needs of airports. And as Mr. Pereira said, there is no national policy requirement for safeguarding to be imposed or to continue. And what we now have to do, what you now have to do, so in my submission, is you do have to have regard to what the framework 106 paragraph C and to some extent E say about national infrastructure. I won't go through that because you've seen it and you've been taken to it today. Now, so I will chime in on and endorse the submissions you've heard from Mr. Pereira and Mr. Vorsdick earlier about GAL's position in asserting that safeguarding is a national policy and isn't a matter for a local plan to make decisions on. It's matter 1, page 4 submission, and so it goes on to say it's the duty of the council to reflect the land needed to be safeguarded as set out in the 2019 master plan. It cannot be found unsound, isn't for this examination to seek to determine whether safeguarding should continue. They're all on page 5 of the matter 2 submissions. 2 points on that. Massive overreach for the reasons we've already heard, and secondly, plain wrong. The justification for and extent of safeguarding is for the local authority to determine, and you now, so both of you, sirs, as the examining inspectors, to test the soundness of that plan. But it is absolutely a matter before you, quite properly, because as Mr. Pereira says, this is the opportunity for the safeguarding to be examined. So it's also very important to note, and I'm not sure this is perhaps featured as much, at least orally today, as it might have done, but since the publication of the airport's policy in 2013, which we've looked at, the Airports Commission, of course, found in favour of Heathrow for additional runway capacity. Since then, GAL is promoting the Northern Runway project through the DCO, we know, that process, which we're told will result in a massive increase in capacity. And GAL are not seeking to progress the Southern Runway, nor is there any realistic evidence, let alone robust evidence, of the prospect of a southern extension. And those are all significant material changes in circumstances since the last plan. I appreciate the Airports Commission report was published just prior to the last inspector's report, but of course you'll be familiar with how the last inspector had approached the issue of looking at that as a potential issue, and secondly the fact obviously there was then a challenge afterwards for a while, but I don't need to detain you with that. But despite those material changes in circumstances, the council seeks to rely on rolling over the land safeguarded in 2015 and indeed has now proposed to be extended in certain extents, we've heard about that by GAL, other than, of course, where it promotes development in EC4 and in relation to potential encroachment for the safeguarding of the route of alignment for the Western Relief Road. So the plan fails to justify the principle or extent of the safeguarding on the basis of robust and up-to-date evidence, we say. And further, the boundaries for the proposed safeguarding area are being applied inconsistently, because we've got an we say unjustifiable removal of it under the allocation EC4, and potentially parts of the potential route of the Western Relief Road under ST4. And I'll just say a couple last points, sir, in terms of the Council's position on this as it's evolved. Because at Reg 18 stage, when the Council, of course, was proposing removal of safeguarding in an area action plan, their position then, and the reference, I think, sir, is 320 of the Reg 18 version of the plan, 3.20, their position then was that the robust evidence for safeguarding required by the framework did not exist. Well, we've seen from the fly-through of the policies, sir, there's been no change in national policy position since then, nor in the local policy, other than that we've had a move to reinstate safeguarding, which is one of the reasons we're all in this room. So paragraph 320 of the Reg 19 version of the plan now, amongst other things, says there is not, therefore, any certainty in government policy that land at Gatwick is no longer needed to be safeguarded. So on that basis, the Council maintains safeguarding, other, of course, than where it doesn't, in relation to EC4 and potentially the relief road. But sir, uncertainty as to the need to safeguard does not equate to robust evidence that justifies safeguarding. So as you will have seen from the more detailed written submissions on behalf of my client, a different strategy, spatial strategy, is required to make the plan sound, with removed or at least reduced safeguarding, enabling a sustainable assessment of employment land to meet the needs of the borough. And that, I hope, is a reasonable summary, so for present purposes, of my client's position, unless I can assist you further on those points.
Thank you for that. For potentially come back to the Borough Council, are there any further points position on sort of the principal approach to safeguarding? Is it Mr. Gallagher?
Yes, the name on that's incorrect, unfortunately. My name's Hayden Kreitzer, representing the Barker Trust. Just to echo a lot of the points that were just made, and I'm conscious we're nearing the 5 o'clock deadline, so I'll try and keep this brief. Our position set out in our representations and written statements, Rep 053, our views are quite simple. We do not consider there is robust evidence exists for the safeguarding, and it's not justified to extend it to land which was previously not identified as such, particularly on the basis of an airport-driven master plan. For the emerging local plan to be consistent with national policy and to be found sound, robust evidence must be provided as part of this review. There is no robust evidence as required by the NPPF, and therefore draft policy GAP 2 must be deleted for the plan to be found sound. As mentioned, it was previously recognised in the draft local plan 2020. There was no robust evidence existed, and the policy was deleted. That's all I have to say for now. Thank you, sirs.
Thank you for that. I mean, I think just as a broad indication at this stage, I mean, I don't think we're going to cover everything on the agenda for today. I think myself and Mr. Rollings will probably go away and reflect on how far we've got in terms of the discussion today on safeguarding, what further information we may require, and then it's very likely we'll need to, I think, reconvene and pick this up again as in the part 2 hearing sessions in January, and we'll try through Charlotte, the programme officer, to convene a date that everybody can attend. I think to assist our kind of initial sort of thought process, whilst we've got sort of time between the part 1 and the part 2 hearing sessions, can I just reaffirm with the council that I understand Mr. Forsdick correctly that the robust evidence is the 2019 master plan, and we're not being directed to kind of other additional evidence alongside that master plan?
No, I think the 2019 one doesn't tell you anything about car parking numbers. It tells you the logic or the justification for the line, for the red line, is only in the 2014 master plan, which was those two documents I asked you to look at on the screen. So that was A5 and A6. So that's what's called the robust evidence upon which Gatwick rely.
And yourself as the Borough Council in terms of continuing.
Oh, I see, safeguarding the rest.
Yes.
I see what you mean. I do apologise.
Sorry, yeah, I should have made that clear.
Sorry. In terms of safeguarding the rest, no, our key point is that, yes, that's a line that shows you what the fundamental needs are, and you can tell where the runway is going to be and so on. And we're not getting involved in the runway bit. We're only getting involved in the Gatwick Green bit because it's a completely different use, functionally separate, and all that sort of stuff. In terms of where the justification for keeping it comes from, it's a sort of inverse justification, which is because the government hasn't made its decision yet, it might well be critical to national infrastructure needs, because we've been told that the government's going to make its decision on post-2030 extra runway capacity post-runway 3 at Heathrow at some point, and they just haven't told us when. Okay. So it's almost like the robust evidence is that we just don't know yet whether it's going to be needed, and therefore the underpinning of the logic for it remains the same.
And in terms of, I call it sort of the more fine-grained analysis of areas that are now no longer to be kind of safeguarded through this plan. We're just wondering, similar to, I don't know, for example, a Greenbelt review or some kind of assessment, has there been a kind of a systematic kind of site-by-site assessment in terms of understanding, well, that's critical and that's not, or has it been as broad brush as, well, that's the area that was kind of identified for surface car parking, and we've kind of dealt with that separately, and everything else is regarded as critical without any kind of further detailed analysis?
That's right. That's right. We were looking, I mean, completely bluntly, the position was that the council identified a need for employment land. The only place to go was to the eastern area of Gatwick. The issue as to whether safeguarding should continue, I mean, there's a fundamental distinction between 2015 and now, because in 2015 the council just went along with it. It didn't have a barrister at the local plan examination, it just went along with it and said, okay, Gatwick says it, let's go along with it, that's fine. Here, in the light of the Airport Commission report, and in the light of the employment pressure, and in the light of general the hiatus that was coming forward with Gatwick and Runway 2, the council undertook a review, and basically as soon as they looked at the detail of it, I mean, it was as blunt as, hang on, how on earth can you need 138 hectares? And that opened the door to Gatwick Green. And it's really as simple as that. And I must say, I'm staggered. I'm literally staggered that at the end of the day, which has been allocated for this issue, and on an issue that goes to the heart of the planning of this area, we still haven't had a single word of explanation as to the justification for the 138 hectares. There is still nothing there at all. And it's quite extraordinary that we've had this for 8 years, and our case has been set out for 2 years or whatever. And my learned friend, Miss Sargent, wasn't able, there's no criticism of her, she wasn't able to point to anything because there isn't anything. There is just one other point I wanted to make, if I may. And this comes back to Miss Sargent's point that, well, we were happy last time round, why aren't we happy this time round? And part of the answer lies in the fact that the council's team has been sitting next to Gatwick in public inquiries, where Gatwick has been at pains to point out how incredibly inefficient its current parking is, and how it can dramatically improve the efficiency of its car parking, which basically opened the door to, hang on, why are we still assuming massively inefficient car parking? It's as simple as that, I'm afraid. There's no rocket science to it. So there hasn't been any. We haven't gone deeper into whether all the other bits are justified, or whether it's justified to remove more from the safeguarding. We haven't done that. I'll be told if I'm wrong on that.
No, other than the explanation in the master plan of the further extent to the south in terms of the geometric needs of the A23 alignment, the river mole diversion and operational needs of the airport. We haven't looked into those or questioned those because they seem logical and sensible.
And so the bottom line position we've got to is that we think it's amply obvious that we can release Gatwick Green, and we haven't gone further than that. That's a fair point.
Putting the Gatwick Green issue to one side, obviously we'll come back to that tomorrow, but just sticking with the points that were made by Ardmore, is it Gallagher's, not Mr Gallagher, Quad, is it the Barker Trust, yes, thank you. About this in principle, I'm recalling the evidence. I think for does the safeguarding go back as far as 2005? Was that where the first? 2008. Mr. Mayor?
I believe it originated in 2003 with the airport white paper, which was a government study.
Okay, so here we are 20 plus years later, picking up submissions from those who have been affected by that for that period of time. The submissions that are being made that through the 2019 Airport Master Plan, there's I'm sure I'll be corrected if I'm wrong from Gatwick Airport, but kind of no immediate intention to deliver the southern runway, but wants to keep the option open. The point that's made now about the concurrent DCO application providing further capacity, as I say, putting to one side the Gatwick Green issue, but just the fundamental principle of whether the remaining kind of safeguarded area is sound and can be taken forward.
The first point, of course, is that it's the area. It is the runway and the ancillary, immediately ancillary part. So it's a different category from the car parking. That's the first point. Second point is that safeguarding is by definition long term, and with respect to airports, probably very long term. And I think the safeguarding, for example, of some of the transport routes for Crossrail and so on has been like there for 30 or 40 years, and so that's not in itself a problem.
So should we, in our minds, be thinking, well, is there a prospect that this could happen within the plan period to 2040? You say, the council says no.
No, that isn't the question. The question is whether you should safeguard in that period to allow any changes either during that period or in due course in national policy. The hiatus that we're concerned about, and that led to our original Reg 18 version that got rid of safeguarding, is simply a matter of the government hasn't made its mind up yet about post 2030, post runway 3 Heathrow, future extensions in the southeast. When it makes its mind up, that will be the answer, and at that point the safeguarding will stay or go depending on government policy. But it's the hiatus that's been caused by the failure to address that fundamental question that means in our view, we reluctantly accept the interim inspector's nudge. Well, it wasn't really a nudge, it was a push, to say we needed to continue to safeguard that which was essential for the possible runway 2, southern runway. I've said quite a lot I hope that made sense, but
thank you. I mean, this is obviously a fundamental issue. As I say, I think, given where we are in the agenda and the time today, we haven't covered probably everything we wanted to deal with by way of safeguarding, so we will timetable in another session. Just on this issue of principle, I mean, I will afford the opportunity now. If there's anything further that either Gatwick Airport or particularly Mr. Keane for Ardmore want to say in terms of the soundness of what the council is doing through GAT2 in this plan, in terms of, I appreciate Gal have a a soundness issue in relation to Gatwick Green, but in terms of the remaining safeguarded land and the approach that's being taken. So I invite Gatwick first, and then I'll come back to Mr. Keane.
Thank you. So I agree with Mr. Forsdick that in terms of whether the principle of safeguarding is sound, the test for you is not, is there a prospect of the southern runway coming forward within the plan period? But I think it is correct that in our documentation, our position is that you certainly can't rule that prospect out entirely. But I also just wanted to draw your attention to page 5 of Appendix 2 to our hearing statement, which is referring to the 2019 master plan, and to 5.4.11, which refers to, and admittedly this is in 2019, but at that point in time there's a reference to the future airport capacity gap that the government's forecasts indicate will occur even with a third runway constructed at Heathrow. So we don't agree that essentially the fact that the airport's NPS kind of came to final fruition more in the intervening period between the Airports Commission work and where we are now, so sort of fundamentally change things in that regard. It's not correct to say that the white paper said that it was for the operator to justify the extent of safeguarding. The reference is 11.81. It was that they were looking to the airport operator to take steps to safeguard the land needed, so I don't think the onus is quite as was suggested earlier. In terms of, I think there is more to say on the issue around the car parking, but in terms of the in principle aspect, I think that's probably it, save that it remains firmly our view that if the principle of safeguarding is up for grabs, then the suggestion must be that the plan would be sound even if you were to conclude that the entirety of the safeguarding should be swept away, and we say that can't possibly be right. There hasn't been a change in national policy since 2015, and certainly not since 2020 when Mr. Ball considered this, that would justify that conclusion.
Mr. Keane.
So very briefly, I agree with Mr. Forsdick and Ms. Sargent that the test is not whether there is any prospect within the plan period, and that's not in no part of our case to say so. But the uncertainty relied upon by the Council, for the reasons I've already said, does not constitute the robust evidence that national policy requires, and indeed the only real change since the Council at Reg 18 stage was satisfied itself that the robust evidence for the safeguarding didn't exist is the critical friend input, as far as I can see from one of your colleague inspectors, valued as it is, but that seems to be the added impetus behind the Volt FAS. Well, you've got a case on why that's not right. So.
Thank you. And I hope anybody with an interest in the examination, we have published a note, I think trying to provide some context to that high-level advice in April 2020. Obviously, we're examining the submitted plan with all of the Reg 19, so Regulation 19 submissions and evidence that postdates April 2020 before us. I'm now going to bring this session to its conclusion. As I've indicated, we will go away from today to try and we will timetable a further session on this, which we hope those with an interest can still accommodate, and I think that will probably get us around the issue around the timing of any sort of GAL response to the York Aviation paper, and an opportunity for people to respond to that, or for the Council to look at that if something is provided, for it to be discussed further, and then we can look at some of the further ground that we haven't covered in this afternoon's session around some of the sort of the practical implementation issues were the principle of safeguarding to be found sound in terms of the application of policy gap 2, and then there's some further just very minor points on policy DD5 on aerodrome safeguarding. If there are no further sort of burning points today, I hope everybody who wanted to have an opportunity has add that, but from the Borough Council.
This is just a timetabling point. If you're going to have another session, I'm afraid from our perspective it will really need to be in that existingly allocated week.
The week one.
Week 2.
Sorry, week 2.
Yeah, week session 2, week 1. The first bit of week, yeah. The 11th of January.
There is reserved time on the 11th of January, so hopefully that would be the...
That's very much where we're probably thinking of going, yep. Okay, can I thank everybody for their submissions and contributions this afternoon. We're probably seeing a number of you again tomorrow morning for matter 4, issue 3. We'll be in the safe hands of my colleague, Mr. Rawlings, for that session. So we'll see some of you again tomorrow morning. Thank you.